But is that a matter of jurisdiction or is it a matter of immunity? The thing that concerned me about your brief and perhaps even the way you're reading the Schooner Exchange case is that these are different concepts. And so it's possible that you're absolutely right that no one contemplated criminal liability of a foreign state, but as a matter of absolute immunity, not, as Justice Barrett was pointing out, if everything else was cleared away. There's no immunity in a particular case or whatever, and then the question is, does the court have jurisdiction? And the language of 3231, it seems to me, speaks to all offenses against the laws of the United States. It doesn't carve out or focus on any particular defendants. And so I just don't understand why you're making a jurisdictional argument. Shouldn't we just be focused on immunity in this case?
Let me go one more time on jurisdiction, then I'm going to give up and go straight to immunity and talk about the FSIA. But on jurisdiction, the argument in both the face of the opinion and every century, there's Barizi Brothers, Samantar, and Kiowa tribes. So you've got a case per century saying Schooner Exchange was a jurisdictional case. The actual government argument of government counsel was, do not misconstrue this statute, because it would be a judicial declaration of war unless Congress gave you that authority. And I read the opinion, but there's 9 of you and 1 of me, and you have all the power. So you're going to read the opinion how you want. But I read it on its face to say jurisdiction. But now let's say, okay, so we're done with that argument. Let me just talk about immunity. To say that you just bypass the FSIA is huge. Congress passed a landmark statute in 1976 against—
in a very particular context.
Exactly.
The context, as I understand it, was that Congress was concerned that Americans who were suing foreign entities didn't have real assured certainty about whether or not their actions were going to be considered, because a lot of the power to identify circumstances of immunity or not was with the executive branch. And so they wanted to codify rules in the civil context for when a foreign country was going to be immune. I don't see anything in the statute that suggests that Congress was focused on or was thinking about immunity for criminal prosecution.
Well, except for the language of a provision that does not limit it to civil, and it's the most fundamental provision in the statute, 1604, which grants immunity from jurisdiction. But it also seems to us, which is said in our opening, that Congress just left this subject to juries, and that amenability to fraud claims, all the special protection. The statute goes on for pages and pages. I have no doubt that Congress was thinking about civil prosecutions, because those are the only kind that ever existed. And I do think it is a big step to say that this court is going to say and leave it to courts when Congress has not spoken. And the only time Congress spoke, it granted broad immunity and then laid down these very specific procedures on how you would ever go about entertaining jurisdiction over a foreign sovereign or its instrumentality.